you. You can be seated. So unfortunately, there's only a one-judge panel again today. I don't know if you had that yesterday or not, but that's where we're at. Okay, you guys ready to start? So appearances?
Yes, Your Honor.
Yes, you are.
Good morning, Your Honor. My name is Serena Campilla, and I, along with my co-counsel, Sophie Ortiz, and Delaney Cornforth, represent the state of Midlands in today's case, in State v. Ryder.
Thank you.
Good morning, Your Honor. My name is Charles Graham, and today I'm joined by my co-counsel, Ms. Avery Wright,
Good morning, Your Honor.
Good morning.
and Ms. Kelsey Hall.
Good morning, Your
Good
Honor.
morning.
Together, we represent the defendant in today's case, Ms. Jordan Wright.
Good morning, Your Honor.
Good morning. Thank you. Recall matters?
Yes, Your Honor. In today's case, we are charging the defendant with aggravated murder. On or about July 14th of 2018 in Polk County, Midlands, Jordan Ryder knowingly caused the death of Parker Page, a child under the age of 13, which constitutes the offense of aggravated murder. Your Honor, we would like to bring your attention to the fact that aggravated murder only refers to the fact that the child was under the age of 13, not to the intensity of the murder.
Okay.
And Your Honor, in today's case, we are going to show that Jordan Ryder used physical force to push Parker Page off the Chrome Loop trail, causing Parker Page to fall to her death.
Thank you.
Your Honor, what are your preferences for movement about the well?
You can move as freely as you like. If you're going to approach the bench, ask permission. Just announce that you're approaching the witness for records purposes.
Yes, Your Honor. Your Honor, we're also going to be entering exhibits throughout today's trial. Would you like to see a copy of the exhibit as the witness is reviewing it, or would you only like to see the exhibit after it's been entered into evidence?
I'll take a look at it once you've entered it.
Your Honor, we would also like to invoke Rule 615 of the constructive sequestration of all witnesses, barring party representatives.
Any objection to that?
We have no objections to that. We'd just like to note that our party representative is Ms. Jordan Wright.
Absolutely. With that exception, granted.
We would also like to invoke Rule 603, the constructive swearing in of all witnesses.
Same.
Your Honor, we also have a binder of materials that you can review throughout trial. These include the indictment and bill of particulars, pretrial orders, relevant Midlands case law, discovery and response to discovery, motions eliminae, rules of evidence, special instructions, and stipulations.
Okay.
Opposing counsel has seen these documents and has no objections.
All right, then you can submit those.
May I approach, Intendant?
You may. Thank you.
And with that, Your Honor, we are ready to proceed to trial.
Thank you. Any pretrial matters from the defense?
Yes, Your Honor, just to, while we don't have a physical notice of intent to offer character evidence document, both parties agreed prior to this trial that character evidence could potentially be displayed throughout the entirety of today's case. We'd just like to note that as a result of there being a notice of intent to offer character evidence, all character evidence is still subject to Midland's Rules of Evidence objections 404 and 666.
Yes, Your Honor. What traits is opposing counsel going to be eliciting?
I'm sorry.
The opposing counsel asked what character traits
Right,
might
okay.
be elicited throughout today's case. They're traits of peacefulness and nonviolence, simply to it.
Any response with regard to that?
No, Your Honor.
Finally, Your Honor, is it safe to assume that all objections are heard constructively sidebar outside the hearing of the jury members?
Yes.
And Your Honor, with that, the defense is also
Well,
ready.
certain objections would be, but.
Yes, Your Honor. With that, the defense is ready to proceed with opening statements.
All right. Just turn my phone on.
court, opposing counsel, members of the jury, today you're going to hear about Parker Page. Parker Page was a 12-year-old girl who was killed on July 14th, 2018. You'll learn today that it was the defendant, Parker's own mother, that pushed her from a 40-foot cliff. On July 14th, 2018, Parker Page and the defendant decided to take a hike on the Leckrone Loop Trail. As they were walking, the pair began to argue. Mr. Kelly Dubes, a fellow hiker on the trail that day, was present to witness the events that occurred on the Leckrone Loop and to hear an argument that took place between the defendant and her daughter. As the pair reached the Calton's Overlook on the Leckrone Loop Trail, the argument began to escalate. Parker Page even began to jab at her mother's leg with a hiking stick that she was carrying. Eventually, Parker began to scream at the defendant. A few minutes later, Mr. Kelly Dubes heard a yelp and then silence. That was the last time anyone saw or heard from Parker Page. Tragically, the next day her body was found at the bottom of a 40-foot cliff, right near the same overlook where she was last seen. Dr. Rachel Quincy will come before you today and tell you that the injuries along the entire right side of Parker Page's body were consistent with that 40-foot fall. But there was one injury, a bruise on her left side, right on top of a broken collarbone, that was not consistent with that fall. Dr. Quincy will explain to you how this bruise was consistent in size and shape with the end of the hiking stick that was retrieved from the defendant's possession. The same hiking stick that Mr. Dubes saw the defendant and Parker fighting over. You're here in court today, members of the jury, because we, the state, have charged the defendant with aggravated murder. We charge the defendant with aggravated murder because Parker Page was under the age of 13 when the defendant killed her. And in the state of Midlands, when someone kills a person under the age of 13, that's aggravated murder. It also tells you what we have to prove to you today. That Parker Page was under the age of 13, that the defendant caused her death, and that the defendant knew what she was doing. It is our burden today to prove this to you beyond a reasonable doubt. Later on in today's trial, as you're listening to the evidence that the state brings before you, read the note on the napkin. By the end of the case today, you'll be able to tie the physical evidence, along with the defendant's motives, to statements that she wrote on a napkin recovered by the police. If you listen to the evidence that the state brings before you today, and you read the note on the napkin, the defendant's guilt will be apparent. So let's talk a little bit about that napkin, members of the jury. When the defendant was arrested the morning after Parker Page was killed, a napkin was discovered in her pocket and confiscated by the police. Soon after, the defendant was charged with the murder of Parker Page. The investigation that followed and the evidence that it gathered will be described to you by Detective Janet Chesney, the lead officer on the case. Detective Chesney will help you to understand the note on the napkin and describe to you the evidence that she gathered, which all pointed to the defendant. Members of the jury, we can't change what happened to Parker Page. We can't go back in time and stop that little girl from being pushed off of a 40-foot cliff. But there is something that you can do. You can bring the person responsible for her death to justice. Members of the jury, as you're listening to all of the evidence presented in today's case, read the note on the napkin. If if you read the note on the napkin and the statements the defendant wrote there, when my co-counsel comes up here later and asks you to find your verdict, there will be only one reasonable and just verdict to be found. A guilty one. Thank you.
Thank you. Okay, it's the defense witness.
Yes, Your Honor. May I proceed? Your Honor, opposing counsel, members of the jury, may it please the court. They have accusations, but they don't have answers. Miss Cornforth just came before you accusing Jordan Ryder of killing her own daughter. And she just tossed out the accusation that Jordan would push her daughter off a cliff. There's a few things they didn't tell you. They didn't tell you about one witness that actually saw this happen. They didn't tell you about one piece of evidence that proves beyond a reasonable doubt that Jordan did it. And that's because they have accusations, but they don't have answers. Members of the jury, you'll hear today that Jordan Ryder cared about Parker more than anything in the world. So when Parker brought up the idea of going on a mother-daughter camping trip, Jordan was thrilled. She bought camping supplies, she set up a tent, and she took the two out for a hike on the Lacrone Loop. And you'll hear that Jordan and Parker went on their hike, came back together, and everything was fine. But soon after, Parker got up and she wandered off. And by the time Jordan realized that Parker had come back, she was terrified. And she looked everywhere trying to find Parker. But before she could, the police had already discovered their body. Today, the state of Midlands brings forth the charge of aggravated murder. Miss Cornforth just came before you, telling you that they just need to prove that Jordan killed her daughter. But this isn't exactly true. Aggravated murder is defined as someone knowingly causing the death of another who is under 13 years old. I just want to break down that definition and focus on that term cause. In order to prove causation, the state has to show first that Parker's death was the natural and foreseeable result of Jordan's actions. And second, they have to show that if not for Jordan's actions, Parker's death wouldn't have occurred. Now they also have to prove that Jordan acted knowingly. In order to show that Jordan acted knowingly, they have to show first that Jordan was aware of her actions and that Jordan was practically certain those actions would result in Parker's death. Now, it's not enough just to prove one or two parts of those elements. In order to find Miss Ryder guilty, the state has to prove each and every part of each of those elements beyond any reasonable doubt. Now, this idea of beyond a reasonable doubt caused us to ask ourselves a few questions. If the state is so sure that Jordan killed her daughter, then we ask ourselves, how did Parker die? When did Parker die? And if those two questions aren't answered by the end of today's trial, we had to ask ourselves the third question: why is Jordan even being accused? As for that first question of how did Parker die, you'll hear today from Miss Jordan Ryder that she has no idea how her daughter died, just that Parker got up and wandered off at some point. But you'll also hear from Dr. Elaine Lopez, a forensic pathologist. And she'll tell you that the state's expert, Dr. Quincy, was wrong, and that an exact cause of death cannot be determined, and showing that not one person in today's case can tell us how Parker died. As for that second question of when Parker died, you'll hear today from Mr. Cameron Lee that he thinks he saw Jordan and Parker together leaving their hike, the same hike the state alleges Jordan killed Parker on. And not one person can give us an exact time of when Parker died. So if by the end of today's trial those questions of how Parker died and when Parker died aren't answered, then we have to ask ourselves the third question: why is Jordan even being accused? If the state is met with the burden of beyond a reasonable doubt, but they can't tell us those two major details of Parker's death, then we shouldn't even be here in court today. And that's why at the end of today's trial, my co-counsel, Mr. Graham, will come before you, remind you that they have accusations, not answers, and he'll ask that you find Jordan Ryder not guilty. Thank you.
Prosecution ready with its first witness.
Yes, Your Honor. The prosecution calls Detective Janet Chesney. Please state your name and spell your last for the record.
Janet Chesney, Chesney.
What do you do for a living?
I am a detective for the Major Crimes Division within the Midland Center Police Department.
And what did you do before that?
Prior to becoming a detective, I was a patrol officer within the MCPD for 8 years.
So what are some of your duties as a detective with the Major Crimes Division?
Well, the Major Crimes Division is responsible for investigating major felonies committed in the Midlands area. These include assaults, kidnappings, and homicides.
How did you get involved in today's case?
I was the lead investigator into the death of Parker Page at Calkins Campground.
How did Parker Page die?
Well, through our investigation, we determined that she was likely pushed off of a cliff at the Electron Loop Trail while on a hiking trip with her mother, Jordan Ryder.
Who did you arrest at the end of your investigation?
We arrested Jordan Ryder.
Do you see Jordan Ryder in the courtroom today?
Yes, ma'am, I do.
Can you identify them by an article of clothing?
She is wearing the brown sweater.
Let the record reflect that the witness has correctly identified the defendant.
No more.
So, Detective Chesney, when you first encountered the defendant throughout your investigation, what state was she in?
The defendant was actually asleep in her tent when we found her the morning of July 15th, 2018. We asked her if she knew where her daughter Parker was, and she told us that Parker was missing.
Well, why did you arrest her?
There were three main reasons: the physical evidence collected, the victim's relationship with the defendant, and the fact that the defendant's story just didn't add up. We also found a note on a napkin that the defendant wrote that really tied the investigation together for us.
I'm approaching opposing counsel and the witness with an exhibit. I'm showing opposing counsel exhibit 26. May I first select your copy?
Okay.
Detective Chesney, I just handed you what's been marked as exhibit 26. Do you recognize it?
Yes, ma'am.
What is it?
This is that napkin that we found on the defendant's person at the time of the investigation, as well as the napkin that the defendant admitted to writing on during their interrogation.
And how do you recognize it?
I collected this personally.
Is it a fair and accurate copy of the napkin that you collected?
Yes, ma'am.
The prosecution offers exhibit 26 and does.
Any objection?
Without objection.
So the,
Detective Chesney, I want to walk through some of the things written on this napkin. Let's start with the bottom right. You'll see a list. Can you tell the members of the jury what that says?
Yes, ma'am. The list reads phone, stick, knife, shovel, and then right next to it, it says Keith, question mark.
Well, did you find any of the items on that list throughout the course of your investigation?
Yes, we actually found all of these items in the defendant's tent, except for that phone, which we found later in our investigation.
I'm approaching opposing counsel and the witness with an exhibit. I'm approaching opposing counsel with exhibit 17. Approaching the witness the same. Detective Chesney, I just handed you what's been marked as exhibit 17. Do you recognize it?
Yes, ma'am, I do.
What is it?
This is the hiking stick that we found in the defendant's tent that we later determined matched an injury on the victim's body.
And how do you recognize it?
I collected this as well.
Is it in substantially the same condition as when you first collected it?
Yes, ma'am.
At this time, the prosecution, or the state offers exhibit 17.
any objection?
Without objection.
So admitted.
Pushing the witness to minutes. Detective, when did you find a phone during your investigation?
About a week after we started our investigation, we received a phone call from a witness who found Parker Page's cell phone next to a dumpster outside of their cafe right next to the Calkins campground.
I'm approaching opposing counsel and the witness with an exhibit. Showing opposing counsel exhibit 27. And let's see. Detective Chesney, I just handed you what's been marked as exhibit 27. Do you recognize it?
Yes, ma'am, I do.
What is it?
These are some of the text messages that we recovered from Parker Page's cell phone.
And how do you recognize it?
I was the one who discovered these text messages.
Is it a fair and accurate copy of the text messages that you recovered?
Yes, ma'am, it appears to be so.
The state offers exhibit 27.
Any objection?
Pursuant to the ruling and the orders on motions in limine, I have no objections.
All right, then they'll be admitted.
May I approach the bench to tender exhibit 27? Detective Chesney, how did this text message exchange affect your investigation?
This exchange corroborated witness testimony that the defendant was arguing with Parker, the victim, the day she died.
Objection, lack of foundation, may I be heard?
You may.
Detective Chesney is claiming that this corroborated witness testimony, but that witness testimony has not been discussed. This foundation foundation has not been laid in order for her to make that connection.
Ms. Franz?
Your Honor, unfortunately, in the state of Midlands, we don't have the luxury of calling rebuttal witnesses. It's important for the detective to be able to tell us that this document directly corroborated eyewitness testimony that she heard throughout the course of her investigation. And further, Your Honor, we will hear from the witness whose testimony Detective Chesney is talking about later in trial today.
Any response back to that?
I just ask that that foundation be laid through Detective Chesney before the claim is made that these text messages corroborate any witness testimony.
And I think what I heard was you asked her what these were talking about, and she started to explain this without talking about the witness that she spoke to and where she got that information. As I heard it, she was just interpreting this the way she felt like she should interpret it, as opposed to the foundation being laid as to why she interpreted it the way she does. So I'll sustain the objection, have you go back and lay that foundation about subsequent case.
Yes, Your Honor. Detective Chesney, how did this text message exchange affect your investigation?
Well, ma'am, I met a man named Kelly Dews on the trail that day, and we discussed what happened with Parker Page. Now, Mr. Dews was an eyewitness to multiple arguments between the defendant and Parker.
Objection to hearsay, may I be heard?
Sure.
Ms. Chesney is using Kelly Dews' out-of-court statements that Parker and Jordan were arguing for their truth of the matter asserted.
Ms. Franz?
Your Honor, there was no statement elicited.
The statement is that Jordan and Parker were arguing.
Your Honor, may I respond?
Sure.
Your Honor, this witness just told us that she found out that Mr. Kelly Dews was an eyewitness to multiple arguments. Now, if she had told us that Mr. Kelly Dews had heard Parker Page say something or the defendant say something, that would certainly be hearsay, but this witness has not elicited a statement onto the record, and furthermore, Mr. Kelly Dews will take the stand later today, but we will not have the luxury of calling this witness back to the stand after Mr. Kelly Dews has testified.
Her statement about what Kelly Dews is going to testify to in the statement is that these people are arguing. Kelly Dews is ultimately going to testify to that as a witness today. It's not a specific statement, but it does help her continue on in the investigation and explains how she gets the previous response to these text messages. So I won't overrule the objection and allow that answer to stand.
Yes, Your Honor.
So, Detective Chesney, this text message exchange, can you tell us which messages are from Parker Page's phone?
Yes, ma'am. The text messages from Parker's phone are on the right of the document.
And what's the last message sent from Parker Page's cell phone?
The last message sent at 4:38 p.m. is that Jordan is angry right now. I said, I love Corbin more.
I'm approaching the witness to retrieve exhibit 27. Detective Chesney, I want to bring your attention back to the napkin. I think you had it with you. Now, if you look at the top right, there's a series of numbers. Can you tell the members of the jury what that says?
Well, it says 10,000 now, and then there's a series of numbers. And ultimately, the defendant circled $200,000.
Did that number, $200,000, become relevant at any other point in your investigation?
Yes, ma'am. These amounts directly correlated with a life insurance policy in the defendant's name that we found in the investigation.
I'm approaching opposing counsel and the witness with an exhibit. Showing opposing counsel exhibit 25. Approaching the witness. Detective Chesney, I just handed you what's been marked as exhibit 25. Do you recognize it?
I do.
What is it?
This is that life insurance policy increase quote I was just talking about.
And how do you recognize it?
I discovered this in the investigation.
Is it a fair and accurate copy of the life insurance policy increase quote that you discovered?
Yes, ma'am, it is.
The state offers exhibit 25 in the evidence.
Objections?
No objections.
May I approach the bench defendant?
You may.
Detective Chesney, whose signature is on this document?
Jordan Ryder's signature is on the life insurance policy.
And who's insured by this life insurance policy?
The only individual that was insured by this policy was the victim, Parker Page.
Who's the beneficiary of this life insurance policy?
The sole beneficiary of this policy is the defendant, Jordan Ryder. Ms. Ryder would have received $200,000 if Parker were to die.
And was it always for $200,000?
No, ma'am, it was recently increased from $10,000 to $200,000.
When was the application to increase that insurance policy started?
The application was started at 10:42 a.m. on July 14th, 2018. This was the last day that Parker Page was seen alive.
And when was the application submitted?
It was submitted at 3:12 a.m. the following morning on July 15th. This was about 9 hours prior to us finding the body of Parker Page.
Thank you, Detective Chesney. I have no further questions. I have a question to the chief.
Yes, Your Honor, but before I begin, may I set up the well for use of a demonstrative?
You may.
May I proceed?
You may.
Good afternoon, Detective. My name is Avery Wright, and I'll be asking you a few questions on behalf of the defense.
Yes, ma'am.
I want to start off by talking a little bit about your investigation. In an investigation, it's important to look at the last time Parker was alive.
Of course.
You have to look at the last place she was seen.
That is correct.
You had reports that Jordan and Parker were on the Lacrone Loop July 14th.
Yes, ma'am. Eyewitness testimony.
In fact, the eyewitness testimony says they were arguing there at 4:30. Is that right?
Yes, that is correct.
So you think 4:30 was the last time Parker was seen?
That is what the eye testimony was. It was approximately 4:30 p.m.
You're familiar with the text messages that Parker sent.
That is correct.
I'm approaching the witness with what's been previously entered as Exhibit 27. Detective, I want to direct your attention to that last message there. That last message was sent at 4:38 p.m., right?
That's correct, which is approximately 4:30 when they were seen arguing.
I'm approaching the witness and retrieving what's been entered as Exhibit 27. Detective, you'd agree with me that to send a text message, you need cell phone service.
That's correct.
So if Parker was sending that text message, she would need to be somewhere with cell phone service.
That is likely, yes.
So if the Lacrone Loop didn't have cell phone service, Parker couldn't have sent it there. Would that be correct?
Well, she could have sent the message, it could have sent later, if she didn't have service at the time, but likely she would have needed cell phone service, yes.
Okay, so if it was true that the Lacrone Loop didn't have cell phone service, Parker couldn't be there when she sent the text.
Well, like I said, she could have sent the text, and it likely would have sent later and said that it was sent at the time that she sent it originally.
So even if it went through at 4:38, Parker couldn't have been on the Lacrone Loop at 4:38 if that's when she didn't have service.
Well, she would have been on the Electron Loop at 4:38 p.m., p.m.
Detective, not at one point in your investigation did you ever investigate cell phone service.
Ma'am, that is correct. We didn't investigate the cell phone service around the entire campground.
So you never checked where did have cell phone service.
Ma'am, the text message was sent at 4:38 p.m., and Parker was seen on the Electron Loop at 4:38 p.m. She would have had cell phone service.
That's a note of my question. You didn't check where had cell phone service.
No, ma'am.
You didn't check where it didn't have cell phone service.
We did not.
And you don't know if the Lacrone Loop had cell phone service.
I did not send a text from the Electron Loop itself to check the service, but the text message was sent after she was seen there at that time.
So that's a note of my question. You don't know if the Lacrone Loop had cell phone service.
I did not check it personally.
I want to talk just a little bit more about your investigation. In the course of that investigation, you've taken statements from several people.
That is correct.
You relied on those statements during your investigation.
Yes, ma'am.
You usually rely upon those types of statements in an investigation.
That is correct. You do rely on interviews.
One of those statements came from Kelly